So, as we come to a close, our final topic of discussion will be on data protection, the rights of the employee, consumer, and direct marketing. Chris and I had a very interesting conversation about this a few months ago. But our speakers today are the Honorable Floyd Green, MP, and Chukwuemeka Cameron. He's the founder of Design Privacy. Now, let me introduce these two gentlemen properly. Floyd Green, his bio says Floyd O'Brien Green. You have to know the middle name, that's important. Is an attorney at law and member of parliament who served as Jamaica's youngest minister of agriculture. A son of St. Elizabeth, he's now serving his second term as member of parliament for St. Elizabeth Southwestern, known as Jamaica's breadbasket. In 2016, he served in the Jamaican government as the Minister of State in the Ministry of Education, Youth and Information, and then was assigned Minister of State in the Ministry of Industry, Commerce, Agriculture and Fisheries in 2019. Floyd believes his greatest achievement is being a father. And then we have Chukwuemeka Cameron, who's an experienced attorney with 21 years at the bar. Chuck has demonstrated a history of working in regulatory compliance in the telecom and financial industry. He's skilled in privacy law, commercial law, and copyright law. Strong professional with a master's in information technology and management from Erasmus University in Rotterdam, with a focus on data protection. And in 2019, he also completed an advanced masterclass training as a data protection officer from an ISO certified provider, IT Governance UK. Incredible sources of knowledge. So let's welcome Chuck and Minister Floyd Green.
Thank you, Kalila. Always a pleasure to see you maneuvering this. Let me say a special good afternoon to Edward Alexander, the chairman of tTech, and your CEO, Chris Record, other directors, of course, Council Cameron, my fellow panelists, other speakers, specially invited guests. I am very, very happy to be here to share today in this discussion about data protection. But first, let me start by just congratulating the tTech team and this TechCon conference that you've been doing for the last 5 years. I think you have really now cemented yourself as the region's top technology conference, with the level of expertise, the abundance of research, and the number of participants that you've had over the years and that you've had during these last 2 days. You are definitely taking strides to advance our digital maturity. I did have the opportunity to stop by yesterday, and I really enjoyed the conversation about tech trends, what to look out for this year. I'm very, very interested, especially the conversation about NFTs and how that can impact the Caribbean space. And then your conversation with Governor Biles about not crypto, I almost said crypto, with our digital currency. Again, I think it was really, really well done. We at the government support conferences of this nature. We believe it's critical to have these frank discussions so that we can listen to the experts and learn from the experts in relation to where we need to be. And we really have adopted a sort of togetherness approach in this journey to digital transformation. And at the Office of the Prime Minister, part of my remit now is to help drive our digital transformation and help to drive that landscape. So clearly it's against this background that we speak about data protection and the step that the government has been taking definitely over the last few years to really recraft our data protection ecosystem in light of our move towards digital transformation. A fundamental step in that recrafting was the passing of our Data Protection Act, which was passed in the lower house in May 2020 and passed in the Senate in June 2020. And really what was a fundamental step by the country and by the government to align our data protection framework with some of the best principles. And we drew a lot from the European Union General Data Protection Regulations, which they had passed in 2018, and looked at various privacy laws to ensure that our Data Protection Act can really help us to revolutionize our data protection landscape. Again, the fundamental and the core of our Data Protection Act is that data should really be only obtained for specific lawful purposes. And our Data Protection Act is underpinned by 8 standards that data controllers will have to adhere to under the Data Protection Act when processing personal data. And clearly, these standards enhance the level of accountability. It will strengthen our digital transformation journey, and it will help in the rollout of our national identification system. And towards the end of the presentation, I will speak about our national identification system and how we see it as fundamental and as the key to ensure that we have a more effective system of social protection, of effective governance, and how it will really help us to enable our business environment and to have a technology enabled society. And more importantly, how we have taken forward steps to ensure that our national identification system aligns with the Data Protection Act. So, what I will do is briefly speak about some of the areas. I'm sure Chuck will go more deeply into it, but I will speak a little bit about the framework of data protection. So clearly, in relation to employees, without a doubt, in this digital era, persons are sharing data at an astronomical level, and the transformation in data processes does allow for many private and public sector offices to handle the personal data of employees. Clearly, that takes into account things like payroll info, employee clients' details, people's expenditures, and therefore it does say that there is a resounding responsibility for employers to keep that information secure. Again, in alignment with some of the best practices for us under the data protection regime that we're seeking to craft, underpinned by our Data Protection Act. The direction is that employers can only process the personal data of employees under certain conditions in all scenarios. The processing should be fair, should be transparent, and should be for a specified purpose and limited to the data necessary to fulfill that designated purpose. It should comply with these following 6 grounds: the consent of the employee concerned, the contractual obligation between employer and employee to satisfy a legal obligation of the employer and to protect the vital interests of the employee, to carry out a task that is in the public interest and in pursuance of the legitimate interest of the employer. It is critical, and I'll repeat, it is critical that the systems are transparent and provides accessible information to individuals, to employees, about how their personal data will be utilized. And again, all of this is underpinned by the provisions of the Data Protection Act. And that energy we take to the protection of the consumer. And I will make the point here that all of this is work in progress. With the Data Protection Act having been passed in 2020, with our Information Commissioner having been put in place December 2021, all of this is work in progress. Again, under the Act, companies were given a 2-year time period to be able to bring their operations into the standards that I now speak of to ensure that they are in compliance with the Data Protection Act. So for us, the Data Protection Act and our drive towards data protection is really to ensure that and to encourage better protection of data for our consumers and to ensure that there are privacy considerations taken into account by people who interact with our consumers. Again, personal information is shared and is collected day to day by businesses. And these include names, email addresses, phone numbers, transaction information. All of this will be regulated under the Data Protection Act. And again, the magnitude of information gives business insights that can improve products and services offers, but it has to be done in a manner that complies again with the Data Protection Act. And the Information Commissioner will be there to regulate and oversee compliance with this act. And we have empowered the Information Commissioner under the act to be able to levy fines, penalties, to start court action if there is non-compliance with the Data Protection Act. The final two areas clearly is in relation to direct marketing and again, our national identification system. And the critical thing in the new paradigm of data protection and how it engages in the employer, with the employer, how it engages with the consumer is about consent. And under the Data Protection Act, a data controller must never process people's data for direct marketing unless the person has consent. If it's a case where the person is a customer and the data controller or business has obtained the contact details in the context of sales of goods and services, there still has to be consent. And again, there is a distinction between coercion and consent, and there is a standard that our businesses and direct marketers will have to live up to under the Data Protection Act. So I would say to those listening on and watching, if you have not yet familiarized yourself with the principles of the Data Protection Act, now is the time, because again, we have put in place an information commissioner, and we are working to build out and strengthen her office to ensure that she can strictly administer the provisions of the act. The final thing that I will speak a little bit about, and you will forgive me as it is, part of my direct supervision, is our national identification system and how it ensures that it prioritizes privacy and data security. I think one of the things about our national identification system, and that distinguishes itself from other forms of ID that we now have in our space, is that at its core, its legislative framework is designed around privacy and data security. In fact, the national identification system legislative framework is explicitly designed to facilitate a consent-based identity verification process on behalf of the data subject. That would be the holders of the national ID in relation to third parties. And this arrangement is entrenched in law. And the only other route for disclosure is via the court. So our National Identification and Registration Act, again, a piece of legislation that everybody should familiarize themselves with. And coming out of that act will be developed our National Identification and Registration Authority, which is the entity that will be established to manage the national identification systems. And its officers are not given the privileges of discretion. In other words, the act makes it clear. Requests for information or for the authentication and verification services is defined under Section 25 of the National Identification and Registration Act. The verification of identity is at the individual's request or an accredited third party with the individual's consent. In addition, Section 24 again makes it clear that disclosure of identity information can only happen under three specific ways. And those are: one, in accordance with the request of an individual concerned, subject to any fee that may be prescribed, in accordance with the order of a judge, or as may be otherwise provided under the Act. And this is a significant departure when compared with existing forms of identification. So even for national security matters, the commissioner would have to apply to a judge of the Supreme Court in Chambers for an order authorizing NERA to disclose the identity information. One of the strong things of our national identification system is that our authority must register as a data controller under the Data Protection Act. So we did have I would say, the honor to design our national identification system with the consideration of the Data Protection Act, because the Data Protection Act would have already been passed in Parliament. So again, from day one, our authority and its officers will be accountable under the Data Protection Act and must comply with those data and privacy standards. Additionally, it's probably the only entity that you will see and the only framework where there's basically a double oversight. So for a national identification system, not only will the Data Protection Act and the Information Commissioner provide oversight in relation to data protection, but we will also have under the Act what is called an identification and registration inspectorate, which will be headed by members of the ECJ, and they have under law to ensure that we are in compliance with all the legislative frameworks that have been put in place in relation to the act and in relation to privacy. So, we have really gone to a very far extent to ensure that NIDS is a consent-based system that takes instructions from the data subject or the owner, and that will have audit trails. And we are going to ensure that those audit trails are protected using blockchain technology so that we can hold the operators of the national identification system accountable. So, in a nutshell, the government is really moving to strengthen our data protection framework. It is work in progress, but we have taken fundamental steps to really accelerate our digital maturity through data protection. So the Data Protection Act and the steps that we're taking on the national identification system, I believe, will go a very far way to completely transform the ecosystem of data protection in our country. Thank you for listening. I look forward to any questions that you may have.
So, Minister Floyd, and let me thank the panelists, the hosts, for inviting me to speak. It was just a pleasure to sit down and listen to your presentation. I had to stop when I was invited to present, especially on this topic in the light of NIDS as well. I was taken back to when I first started this evangelization journey about 3 years ago now. And I recall where in my first presentation 3 years ago around data protection, we were talking about the value of data. And then the legislation wasn't passed yet. So after we started to speak about the value of data, we then started to speak about the rights of data subjects. And then come 2020, we're now able to be 21, we're in a position to start speaking about the rights provided for by the Constitution under the NIDS decision. And now we have the Data Protection Act. So it has been a very interesting and exciting journey. More so the fact that we have recognized that data protection is the foundation of digital transformation. For persons in the digital transformation space, I am going to invite you to take one step back and look at the Data Protection Act as a tool to drive digital transformation. Why do I say so? The Data Protection Act sets out specific steps that you must take. And all these steps speak to are steps that are fundamental to building out a digital ecosystem. It gives you or prescribes for you guidelines as to how you process your data. So if it is you don't have a clue about what digital transformation is or how to do it effectively or efficiently, just comply with the data processing standards. I am going to jump into my presentation now, and so if you could just go to the next slide. So, what is important from the consumer perspective is that the biggest data controller in Jamaica is the government of Jamaica. NERA, through NIDS, will represent one of the biggest data controllers. So it's quite appropriate to couple consumer rights, data protection, and I'm going to use the opportunity to focus on it because we do want to establish as well, from the practitioner commercial point of view, we see NIDS as one of those drivers that will accelerate digital transformation in no uncertain terms. So while we had a commercial view, our constitutional court stepped in and said, yes, we see the value in that. But at the heart of this innovation, in terms of this national ID system, are constitutional rights, namely the right to informational privacy. And if we are going to accelerate digital transformation by rolling out such a system, we have to build out this system, and at the heart of this is our privacy rights. And so essentially the NIDS decision said four things. The action must be sanctioned by law. And we heard Minister Green set out very briefly and very concisely that law that actually sanctions and facilitates the offering of this service. There have been studies that have established, well, one study by Capri, I think in 2020, that demonstrated that it was necessary and spoke to the proportionality of it. And then there must be procedural guarantees against abuse of such interference. And we also heard of the accountability structure that has been built into the Act. So that is the first step all government agencies and all data controllers must take. Go through this test. Is the reason for processing personal data legitimate under the law? That's the first test. I've coined, over the years, I've coined this term and this approach that from a cybersecurity point of view, practitioners should appreciate. In cybersecurity, you have a zero, well, the new approach is that you have a zero trust approach. From a data protection point of view, we have coined this term. You have a zero rights approach to use anybody's data. So when we use NIDS as an example, they have their legitimate reason for using the right by virtue of that piece of legislation. And so all government agencies, before they can process anybody's personal data, there must be some lawful basis for them to process that data. So if we could move to the next slide, please. And again, it was a pleasure to listen to Minister Green. And why do I say that? Because the emphasis was not around the information security controls that have been built in. While in essence, that's what he spoke to, he did not reference information security, because let us be clear, and I think this is very important in this setting to understand, and if this is the one insight that I want us to leave with, information security does not amount to privacy or data protection of personal data. There are two distinct things. So you could employ or deploy the best information security controls. It does not mean that you would have complied with the Data Protection Act or respected the right to privacy that citizens now enjoy. Next slide, please. So, information security more speaks about protecting and controlling the access or flow of information within an organization or between that organization and its outside entities. Methods, typical foundational things that you'd have heard from Chris and his partners speak to earlier, was the whole question of encryption, identity and access management and firewalls and those sort of IT controls. Next slide, please. On the other hand, Privacy helps to safeguard important values such as human autonomy and dignity. Methods include robust ethical norms, principles, practices, and organizational policies with governance mechanisms employed to uphold, maintain, and evolve those norms, principles, and practices. So, building out a robust privacy framework in accordance with the Data Protection Act has very little to do with ensuring you have firewalls in place, that you have monitoring in place, that you have blockchain to build out the to track the audit, to be able to audit the activities that have been taking place. It is something totally separate and apart. And while this may seem hairy-fairy, and you may ask yourself, okay, assuming we accept what you say, what do you mean when we say ethical norms and principles? What do you mean when we say that? The legislation speaks to that. The legislation sets out what specific data processing standards are. And it is these same data processing standards that we're not going to get into for this presentation that I say also capture what solid digital transformation processing should look like. Next slide, please. So the Data Protection Act establishes a framework for entities such as NIR and all companies processing personal data to protect the informational privacy rights. It prescribes and states what those data subject rights are. And this is what I want us to appreciate. It mandates specific data processing standards. These data processing standards are not information security controls. They are not information security solutions. They encompass and present in a more fulsome way this concept that you do not have any right to be processing any data unless you can justify it. So, for example, it says that you must first have a lawful basis to process data. And that's the first point I tried to make. And that lawful basis means the Data Protection Act sets out what those 6 lawful bases can be. And if you cannot fall within one of those specific 6 lawful bases that have been established by the legislation, you have no right to be doing so. You can be prosecuted. You can end up in jail. It also sets out that if you are processing data, you must notify the data subject. And notifying the data subject isn't hairy-fairy. The legislation also sets out what you must inform the data subject of. And it goes on. Importantly, in terms of building out a privacy framework, the legislation also speaks to mandatory processes that you are obliged to implement to enable the exercise of the data subject rights that have been afforded by the Constitution and by the legislation. And importantly, to create that full circle and for it to be a true management system, it has created reporting and a monitoring structure, which falls under the remit of the Information Commissioner, who assumed their office in December 21. That pause means next slide, please. Right, so in preparing this image can look more, I like pretty pictures. This is not a pretty picture, but I think it captures the core message that I want, the second core message that I want all of us to leave with. So think about replace NIDS with the name of your company. Replace NIDS with the name of your government agency. And you see 3 circles on the outside. One says process, people, process, and technology. When we talk about digital transformation, we have heard the common terms. We have to be looking at people, process, and technology. And imagine this image without the thing in the middle. That is what your business currently focuses on. What are the people, processes, and technology do you have in place to drive value for your customer and drive value for your shareholders? That is an information technology discussion, and that's a business management discussion. What processes or what infrastructure do you have around your people, technology, and processes to deliver value to your customers or consumers? If it is you are processing personal data, as all of us are, and more specifically, Nero, at the heart of that, you must build out an equally robust structure that speaks to people, technology, and processes around protecting the consumer right to privacy. So, yes, I didn't, there was no pregnant pause there, but yes, time is running, so I will work with that. Yes, next slide, please. So, what do we mean when we say process to protect the privacy rights of individuals? The legislation has mandated a number of things that you need to put in place in terms of processes. You must have in place your data subject access request process, your personal data incident response plan, your data protection impact assessment, which must be documented and done, consent management processes, and it continues. Next slide. When we talk about people, we have to ensure that an organization is made up of people. The board must own the risk. The board would have had to allocate the appropriate resources to protect privacy. They would have had to appoint the appropriate data protection officer. There must be a project team set up to drive it. You may need privacy champions. Next slide. There must be persons in the organization responsible. Next slide. Appropriate persons mean they have the competence and training. As it is now, in your organization or in NIDS, do we have people that are appropriately trained, not in information security, but data protection? Are your staff members aware not only of cybersecurity awareness, are they aware of data protection awareness? The law mandates that all persons that touch or have anything to do with personal data in your organization must be aware of the data protection controls that you would have implemented. In the absence of that, you can be exposed to criminal sanction. So this concept about awareness, cybersecurity awareness, and that may be a nice to have because employees are the weakest link. It's no longer optional. The law says that all persons must be aware. So this training is now mandatory. There, we must, yes, please, next slide, that's correct. Next slide, please. We must design capabilities to empower consumers to enforce their privacy rights. And you could stay there for a while because I'm going to wrap up around this slide. It is only in the building out of this robust managed privacy management infrastructure can you say that you would have started to comply with the Data Protection Act? Can you say that you are respecting the rights of the consumers? So I didn't use this opportunity to look at the individual rights or individual employees or case studies. The focus must be on ensuring that you not only have the security controls, but you have a robust privacy management system that recognizes the fact that we are processing personal data. And because we now have a constitutional right to informational privacy, you are also treating with and accountable for one's right to informational privacy. On that note, I'm going to thank tTech for having this opportunity and share with everybody online an offer that we also have in conjunction with tTech. While tTech has unlimited resources and they can just offer free 4-hour sessions to an unlimited amount of persons, we have to limit our offer to the first 10 persons because our resources are not unlimited. So for the first 10 persons that apply, we are prepared to sit down with the CEOs and or the board of your organization, be it a private sector company or government organization, and walk you through in a much more in-depth manner what your obligations are under the Data Protection Act. So, if you forgot everything that I said, it didn't mean anything went over your head, let me introduce a new thing that I want you to remember. The first thing that you have to do or you go to jail is register. So put yourself in a position to register. Registration, the act of putting yourself in a position to register, takes upwards of 12 months and it's very fulsome. It's a very engaging or involved exercise. Thank you again. We are open for questions and I hope I was able to lend some clarity or insight into what data protection in the context of consumers and it is all about. And we are anxious and happy to be participating in this exciting moment in Jamaica's evolution, where we are seeing digital transformation being led by the government and private sector and having data protection and cybersecurity as a foundation. So we are really here to work with government and work with private sector's organization to reap the benefits of what digital transformation has to offer. Thank you very much.
Thank you, Chuck, and thank you as well to Minister Green. We do have quite a few questions, so let's start with one from Damian Donaldson. What is the current state of readiness of government agencies for their own compliance with the Data Protection Act? Great question. I guess that's for Minister Green.
Yeah, so definitely the government agencies are working to be in compliance. I think the Data Protection Act appreciated that it would take some time for all the government agencies not only to do the requisite training that Chuck spoke about, but also to ensure that their systems are so organized. So the Data Protection Act did give a 2-year window in which our government entities have to get themselves in compliance. And definitely all our big data controllers and all agencies are working in that direction. For national identification system is a little different. We have to be ready from the get-go. So we're organizing our systems to align directly with all the requirements of the Data Protection Act. So the government agencies are working in that regard. I know the Ministry of Science, Energy and Technology is playing a critical role in helping some of our government agencies, especially through eGov. But yeah, we're working in that direction.
Another similar question. I don't know if that 2 years that you mentioned also applies to the private sector, if that's only for government, but Brandon asks, is there a deadline for compliance with the Data Protection Act?
Yeah, so the 2 years applies across the board. The 2 years applies across the board. So it is critical that one, or companies, as again Council Cameron indicated, get themselves familiar with the provisions of the Data Protection Act. It is a new paradigm, and at the center of the paradigm is the rights of the data owner to their data, right? So all systems that have been organized that accesses data and uses data without consent or without legal right to do so have to be completely changed. So the 2 years is for everybody to comply. The 2 year was given right across the board for both government and private sector.
If I could expand on that, from a practical point of view, well, the first thing you want to be focusing on is registering. That's the first thing the legislation requires you to do. The second thing that you want to appreciate is that compliance is an ongoing exercise. It is not something you're going to finish in 2 years. It is not something you're going to get right. But what is necessary from our perspective that we try to do for our clients is ensure that they have started the journey. And you have to start the journey at the top. Once you can demonstrate that the board has taken on this issue and have started to put things in place. So from a government perspective, the very awareness of it and the sort of messaging and signaling they have started to make, there must be that sort of ownership and acknowledgement, and then systems starting to put in place. But it's not something that will be done completed right away. What that 2 years speak to is that the information commissioner will not sanction you within the first 2 years
Mm,
unless she thinks that you're acting in bad faith. So the 2 year transition period isn't a get out of jail free card. If it is, she forms a view that you have acted in bad faith. And what that means is that she has gotten a report about a big data breach. She sits down with you and says, how did this happen? Okay, no problem. This is the bare minimum I want you to do to fix that. And something happens 2 more times, you are now acting in bad faith. So even before the 2 years, you can be sanctioned. And this
got it.
information commissioner has said so.
Got it. So there's a lot of information that is needed, and I know that there have been quite a few efforts to sensitize the public and especially business owners. But Brandon still wants to know, will the government be offering sensitization workshops or training on the provisions under the Data Protection Act?
The simple answer is yes. I think critical to that was getting in place our information commissioner, which we did in December last year. And now, again, I know the Ministry of Science, Energy and Technology is working with the information commissioner to build out her staff complement. It's definitely one of the areas that she will be focused on, and also the Ministry of Science will be focused on in terms of getting the information to people. So the simple answer is yes, you can look for that during the course of this year.
The next question comes from Christopher. Considering that you're collecting biometrics, fingerprints, how do you plan to allow for revocation of compromised fingerprints?
Very good question. I always say in forums of this nature, Kalila, that I'm not the tech person. I am the policy head. But suffice to say, there are provisions for the revocation under the Act, under the National Identification and Registration Act, in terms of the actual steps that will be taken. I can't tell you the direct steps, but I can tell you that it is accounted for. And once it is accounted for, then it means that process will be put in place to facilitate that happening.
If I may add to that, I note the focus on biometric data. Under the Data Protection Act, while you may need additional permission to use biometric data is not that much more special than a business using somebody's name or email address. So there has been a perception that there are certain things that are certain types of data that are extra special. And we don't have biometric data, we don't have criminal records. The Data Protection Act protects your name, your email address, your license plate number, anything that can identify you. And the only difference under the Data Protection Act with something like biometric data is that you would need one extra level of permission. However, having looked at the NIDS legislation, as Minister Green said, it does have a detailed process as to how it would revoke or reverse those types of things once consent is no longer available.
Interesting that there's no distinction under the law, because people do consider biometric data to be extra special because it's unique to you, but it has the same protection under the law, under the new Data Protection Act, as other things such as your name. So Colin wants to know, considering the responsibilities of the data controller, should the position report to the board similar to that of the internal auditor?
So interestingly, the data protection officer or the data controller is answerable to the information commissioner. So what does that mean? If it is the data protection officer observes that you are breaching one of the data processing standards, the first thing he has to do is bring it to the CEO and the board and say, hey guys, the law says we must do this, you're not doing it. And they fail to remedy that situation, the law obliges the data protection officer to go directly to the information commissioner. And to safeguard his position, the law also says that the data protection officer must be an independent, free of conflict person that does this for you, because he should not fear losing his job if he reports directly to the information commissioner. So the legislation does contemplate exactly what you just asked, sir.
So, a quick follow up to the earlier question about whether there'll be public sensitization sessions. Robert wants to know when that awareness campaign will start.
Right. And I guess there will be two sets of awareness campaigns, but clearly, especially based on all that I presented today, as you see, they dovetail into each other. We do expect to, by the second quarter of this financial year, to embark on a massive uh, coordinated sensitization program for our national identification system. So, by mid-year, by about June thereabout, we want to get that going. We're now in the process of choosing. We've gone through a tender process to choose a communications consultant that will help us drive that, and that will incorporate especially aspects around a national identification system that touch on concern the Data Protection Act. Outside of that, I wouldn't speak for the Ministry of Science, but I did sit with Minister Vaz, and we did sit with the commissioners who oversee the Information Commissioner. And I would give about the same time frame as about mid this year. You should see a massive sensitization effort. Now, clearly, it's something that has to be continuous, right? So even if we start, it's something that has to keep going. I know already the Information Commissioner has accepted requests to speak at conferences and has started this sort of journey in terms of sensitizing. And clearly, part of what we're doing here is a part of that journey. But there will be a more robust, coordinated approach that should start the second half of this year and go down to the end of the year, and that will continue into next year.
If I could,
Around June. Yes, Chuck?
let me put a spin on that, because I fear a lot of the sensitization is, let's say, free legal advice for companies or data controllers as what they should do. Profit making companies have the ability to find that information. They need to be aware of the fact that there is a law that requires them to do something. So yes, it has far-reaching impact. So there should be some level of sensitization that the government facilitates. The real sensitization needs to turn around the new constitutional rights that citizens now enjoy, and the rights that they have to hold the government accountable and to hold data controllers in general accountable. So I would love when in the rollout of this awareness campaign, that heavy focus is placed on the rights that data subjects, citizens of Jamaica now enjoy. Right now, if I were to ask any of your listeners, what is the Fifth Amendment? A lot of you would know. Because we watch TV, we know that Americans have the right to bear arms. We know all the American constitutional rights. We do not know our constitutional rights. And if we're going to start anywhere, let's start with what it means when we say we have the right to informational privacy. What does that mean?
Mm. Very, very, very important point. So for our participants, I have two poll questions that I'd like you to answer. I also have one more question from the audience that I want to pose to you before we wrap. So the first poll question for the viewers: do you know the first step in becoming compliant with the Data Protection Act? Yes or no? Simple question. Do you know the first step in becoming compliant with the Data Protection Act? And now I'm going to take the final question from Natasha Levy, who wants to know, how will I know if my company will need to be compliant with the DPA? What if I have a small business and sell on social media? What about a small cleaning service?
I'm sure Chuck is going to take this one, but once you collect data from your customers, then you have to ensure that you're in compliance with our Data Protection Act. But Chuck, you want to speak?
So I'm going to first. I don't like exams, so I'm going to help people with that exam question. So if you guys remember the last thing I said in closing the presentation, that okay. So that's an aside. In terms of answering a specific question, um, we are actually working with 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 institutions to provide for those small entities that don't have the resources of big companies to put these systems in place. it is a bit premature to speak to it, but the fact is that the legislation does encompass churches, charities, that pan chicken man who has your phone number in his phone for the purposes of calling you to say your food is ready. All of them are governed by the Data Protection Act, and that's because we're speaking about a constitutional right. So all of us enjoy the constitutional right to privacy, and as such, everybody must respect it.
And here's the final poll question for the participants. The Data Protection Act has implications in how you store your customers' data. If exposed, you will be fined. Do you want to learn more? Simple question, yes or no? Yes or no, take that final poll question. Thank you so much, Minister Green. Thank you so much, Chuck Cameron, for joining us and making that insightful presentation.
Thank you
No
very
problem.
much.
Thank you. It was a pleasure.